Welcome to the League of Women Voters of Washington, interviews of candidates for Supreme Court justices in the August primary. The League is a nonpartisan organization. We never support a candidate or a party. My name is Wendy Colbert, and my guest is Scott Edwards, who is running for Justice Position 1 on the Washington State Supreme Court. We are asking all the candidates for this office the same 4 questions. Each candidate has up to 90 seconds to answer each question, and the answers are timed. This video of candidate Scott Edwards' responses will remain on our website until after the primary elections on Tuesday, August 4th, 2026. Candidate Edwards, thank you very much for agreeing to this interview and seeking to serve in public office. Our first question is, what are the benefits of being or not being a judge before running for the state Supreme Court?
Well, I've spent more than 30 years as a tax attorney and more than 20 years teaching state and local tax at the University of Washington School of Law. I think that experience makes me uniquely well qualified to serve on the state Supreme Court as a state Supreme Court justice. The primary role of the state Supreme Court is to interpret Washington's statutes and Constitution. Tax law is statutory. And in my practice, my job is to interpret statutes and advise my clients about what the law says, regardless of what my opinion is about whether it's good tax policy or not. The same is true with my teaching. In my role as an educator, I teach law students and practicing lawyers principles of statutory interpretation and constitutional analysis. And again, the primary role of the Washington Supreme Court is to interpret the law as written and in accordance with the Constitution. So my experience doing that for more than 30 years, both as a practicing attorney and as an educator at the University of Washington School of Law, I think is directly focused on the job of a Washington Supreme Court justice.
Thank you, candidate Edwards. The next question is, how would you approach a case in an area of law in which you have no knowledge or experience?
Well, the Washington Supreme Court is an appellate court. It's not a trial court. And the starting point in any appellate case is the record that was created at the trial court level, which is where the relevant facts are established. Whether the judge has familiarity with the subject matter of the dispute or not, the starting point is always to review the record and to read the briefs that were submitted by the attorneys for both sides. I think it's also important to read the cases that the attorneys cite as precedent to make sure that the cases say what the attorneys claim that they say and evaluate how close on point they are or not. But again, the focus first and foremost is not on being a subject matter expert about a particular topic, but on being an expert of interpreting statutes and the Constitution, something that I've spent more than 30 years doing on a daily basis. The focus, there is statutory interpretation, not administration of policy.
Thank you, candidate Edwards. Our next question is, when is it appropriate for the judiciary to overturn a statute or popular referendum?
Well, the short answer is only when the statute or referendum is unconstitutional. The Supreme Court's role is to interpret the law as written and in accordance with the Constitution, not for the court to impose its own policy preferences. Our government is structured with a separation of powers among 3 co-equal branches of government. And in Section 1 of the Constitution, we note that all political power is in the hands of the people. So the people can directly legislate through initiative or referendum, or legislature can enact statutes. That's their role. It's then the executive's role to enforce those statutes, and the Supreme Court's role is simply to interpret them as written and in accordance with the Constitution. So if a statute or referendum is constitutional, the focus is to apply it as written, not to add or subtract anything to or from it.
Thank you, Candidate Edwards. Is there a judge or justice in history or today that you most admire, and why?
John Marshall, one of the early U.S. Supreme Court judges, because in the case of Marbury versus Madison, the Supreme Court established the principle of judicial review, and that is clearly reflecting that under our form of government with separation of powers, it's the role of the judiciary to interpret statutes as written and in accordance with the Constitution. That serves as a check and balance on the administrative and on the executive and the legislative branches. But each branch has its own role in our government, and it's not the point of the court to be a super legislature or a super executive, but to interpret statutes as enacted and as consistent with the Constitution.
Thank you. And thank you again for giving the public this insight into your views and values. Viewers, please don't forget to vote by August 4th. There are numerous county elections office ballot boxes throughout the county. There's a list of locations on our website and on the county elections website. This concludes our interview.